Hi, this is Erica Merrill, and I'm the founder of Perfect Legal Video. I'm very excited to bring to you this week's SVL Insights. And we have, as usual, Attorney Jim Sorenson. He is one of the founders of Sorenson Van Leuven Law Firm down in Tallahassee, Florida, and they handle cases for credit unions specifically. So I want to welcome you to the show today, Jim. Thank you so much for joining us.
Thank you for having me, Erica. Happy holidays to you.
Happy holidays to you, and thank you so much. So we're in the middle of our series called the What Is series, and this is the second installment, I believe. We talked about foreclosures last time, but this time we're specifically going to talk about the chattel foreclosure. So let's talk about what is the simple definition of a chattel foreclosure, and then we can get into the nitty-gritty.
Sure. I think the place to start is let's define a chattel first, and then we'll give more of the definition of what the chattel foreclosure is. So a chattel is not a word we use. Most people, unless you're a lawyer, you don't use this word very often. But it is an item of property other than real estate. So it's any property that someone owns that isn't real estate. And therefore, a chattel foreclosure is a legal action whereby the creditor who holds a lien is foreclosing on some piece of property that is not real estate. So personal property is generally what we're talking about. And through the chattel foreclosure, they're seeking to enforce a lien against that property. Examples of chattels that come up in this legal context typically would be a motor vehicle, a motorcycle, an RV, a boat, equipment, machinery, things like that. Those are kind of the common examples.
Every time you say RV, I always think about my RV, and I'm like, did I make my payment this month? Oh, yes, I did. Love the RV. So that's a really good definition. Anything but real estate. So when we're talking about these foreclosures, a lot of times we talk about process. Is the process similar in different states, or does the process vary?
Yeah, my understanding is the process is going to vary from state to state. I'm certainly not familiar with all the 50 states' laws on this. But what we're going to talk about today is Florida and Georgia, two states that I'm licensed to practice law in, and where we handle these types of matters. And there is a difference in those two states and differences in how those cases proceed forward.
In these cases, do you always have to go to court?
Yes. So a chattel foreclosure is going to go through the court system, different than when we talked about real estate foreclosures last time. In Georgia, you could have non-judicial foreclosure of real estate. That doesn't exist in the chattel foreclosure cases.
I know. I was really surprised when you told me you stand on the court steps. Excuse me. When you told me that you stand on the court steps and just sell it to the highest bidder.
Yep. That's a unique thing in the real estate foreclosure world where that happens in a state like Georgia. But this is not that case. These are going to go through the court system and be controlled by the court.
So when is a chattel foreclosure necessary?
Yeah, so a chattel foreclosure is not a common remedy with our credit union clients. We don't handle these all the time. And the reason is because most of the lending that is done by credit unions is done on collateral, motor vehicles, boats, RVs, and the like, that they can recover through self-help repossession. And once they get possession of it, they can transfer title through what's called a repossession title. So it's an administrative procedure. It's not a court procedure. So when you do an auto loan at a credit union or a bank, whoever, if you don't pay that loan, they have a legal right under state law to come and take possession of it. We all know that. We know that repossessions happen. And then behind the scenes, in order to transfer the title from the borrower to the lender so that the lender can sell the car or whatever it is, there is an administrative process through the appropriate state agency. In Florida, it would be the Department of Highway Safety Motor Vehicles, so that a repossession title is issued. The car is now titled in the name of the lender, and the lender can now sell the car. So this situation arises, chattel foreclosure arises where repossession is not possible because the lender does not have a perfected lien on the property. So again, in the case of an automobile, the lender never recorded their lien on the title to the vehicle. They have a lien, they just don't have it recorded on the title. Therefore, since they don't have it recorded on the title, they can't get a repo title, they can't repossess the car, so you're left having to go through the court system to do what's called a chattel foreclosure. And this comes up probably most common with auto loans, but like I said, it can come up with other types of loans, boats, RVs, other loans made on chattels. And it's usually situations where the lender has been unable to successfully record their lien on the title of that vehicle.
So can you give us an overview of what a chattel foreclosure is like in Georgia?
Yeah, so in Georgia, it is a more abbreviated process than it would be in Florida. In Georgia, there's a lawsuit filed, but pretty much upon filing the lawsuit and filing the necessary documents with the court will issue a writ of execution. And that writ of execution instructs the sheriff to go out and take possession of the chattel, the piece of property, and then to put it up for sale to satisfy the outstanding lien to the creditor. And so that process is a fairly quick process unless the defendant comes in quickly and establishes some defenses. But even then, the process is more abbreviated in Georgia than certain other states. So these tend to move rather quickly in Georgia.
I mean, that's very interesting. So whenever we talk about Georgia, the next thing is we always talk about Florida, which is where you are. And so give us an idea of what the judicial foreclosure is like in Florida.
Yeah, so in Florida, it's a little bit more of an involved process than Georgia. We do have to file a complaint of foreclosure. So the complaint is going to be similar to a real estate mortgage foreclosure. The lawsuit is filed against the borrower and the owner of the property. Typically, that's the same person, but in some cases, you may have a borrower who's different from the owner. And then if we're dealing with a property that is titled, like a motor vehicle or an RV or a boat, then we have to name the Florida Department of Highway Safety and Motor Vehicles as a defendant in the lawsuit. Because the goal of this legal action is to get title into our name. We are seeking, one of the things we are seeking is an order from the court that instructs the Florida Department of Highway Safety and Motor Vehicles to issue title in our client's name, so that the client then can proceed to sell the car or the collateral. If the lender does not have possession of the collateral, then as part of this lawsuit, we are also seeking a writ of replevin, which is to get possession of the vehicle. We've talked about what a replevin is before, so I'm not going to go into detail on that. But because we're having to serve multiple parties, and then there has to be a hearing, this process just takes longer. And it's not uncommon for this process to take a year or longer to work its way through the court system.
That's a long time to wait. I mean, that has to have quite the negative effect on the credit union.
It is, and this is usually a last resort. In most of these situations, the credit union is trying to work with the borrower to get the title perfected. So usually the issue arises because, for whatever reason, the dealer either didn't properly process the paperwork, or it was a private sale and the borrower was supposed to go to the tag agency and take care of the process themselves, and they don't do that. And so the credit union will reach out. Hey, we need you to do this. Here's the paperwork. Here's the check you need to take to the local tag office. And when that doesn't work out, then obviously the last resort becomes a legal action. Most cases, this is resolved without legal action, but when it does have to go to legal action, unfortunately, it does take a long time.
I mean, and that is why you have the right processes and procedures to try to avoid things like this that may take your money away for a long period of time. I mean, do you see that this is something that needs a lot of training in some of the credit unions?
Well, I think it does happen. I wouldn't say it happens a lot, but it does happen that there are times where when we see this happening often at one particular client, that's usually an indication that there is a training issue or there is a process issue, or maybe both. And so, those need to be addressed. And we'll certainly look at that as part of, hey, what's going on here? Is this a one-off situation, or is there a process that is broken down that needs to be revamped? Because as you pointed out, this can get costly, and this can cost the client money. So we want these to not happen very often.
Yeah, and I mean, I know it's frustrating when you think that you have a process going, and then you don't even realize when it broke down, and then all of a sudden it's like a leaky bucket. Like your bucket's empty, and you're like, what happened to all my money? And so that's why your clients are so lucky that they have you.
We certainly try to help them in those regards.
So tell me a little bit about, like, after the foreclosure, can the lender pursue a deficiency balance if the property does not have enough value to cover the outstanding debt owed?
The simple answer to this is yes. The lender can pursue the deficiency balance. This is often in Georgia, it's going to require a separate lawsuit. In Florida, it may require a separate lawsuit. It kind of depends on how you structure the original lawsuit. But a lot of times we see this as a separate lawsuit because you're pursuing different parties in this case. But yes, there is a process to go through and get your deficiency balance if the collateral itself doesn't have sufficient value, doesn't bring a high enough sales price to pay the loan off.
So what is one mistake that you see your clients make with the chattel foreclosures?
Yeah, so I think taking matters into their own hands and not consulting an attorney. Often the client will attempt to resolve this on their own, and those attempts can be like trying to repossess the collateral. And the risk there is that they would face a claim of wrongful repossession. So now what is already going to cost you some money becomes significantly more expensive. So this arises in a situation, as I talked about earlier, typically when this situation arises, the credit union does not have a perfected lien on the collateral. So in the case of an automobile, there is no lien on the title to that automobile. So what can happen is the borrower can figure this out. Oh, wait a second. I have this car, it's titled solely in my name. It doesn't show that there's a lien holder. I can go and sell this car to some third party and get cash and pocket the cash, and no one's going to realize that ABC lender, ABC credit union, had a lien on the car. And so the credit union goes out and repossesses the car, and meanwhile the car has been sold to this third party. And so the third party now has a claim for wrongful repossession. That third party in that scenario that I just described is going to be protected if they bought the car in good faith, meaning they paid a fair price for it, and they did not know that there was a creditor who had an interest in it. If they approach the person and say, hey, do you own this car free and clear? And the person says, yeah, here's the title. There's no further inquiry required. So you need to be careful in these situations. So I always think when this situation arises, the clients need to reach out to their lawyer, or if we're their lawyer, to reach out to us and let us walk through the process. Hey, what are the specific facts in this case? What do we need to do next? What are the steps to take to make sure that we get the collateral back and are able to sell it, but that we do so in a way that doesn't increase the risk or the potential fallout to the credit union? Because again, in these cases, usually when these are pursued, you're going to have to pay legal fees. There's going to be cost involved. The car is sold. There's still an outstanding obligation. So your outstanding loan is not paid in full. And then you have to add on to that. Now we're defending a lawsuit over a wrongful repossession and in a fight with some third party, and the credit union may have to pay money to that third party. So we want to avoid that. And sometimes people just want to take it into their own hands and fix it quickly. And a quick solution is not always the best solution.
Yeah, no, absolutely. I can't believe that they think they can do that. It's funny what people do when they claim not to know the rules, right? So they just do whatever they want. Sure, it backfires and it's not good for anyone, especially that poor third party that didn't know.
Yeah, exactly.
Well, this has been an eye-opening interview about something that I hadn't thought of. And certainly some of those scenarios are complicated. And definitely, if anyone out there is watching this and they're part of a credit union and they would like to really get their processes in order to avoid mistakes like this, please give Jim a call over at Sorenson Van Leuven or any of his team. They're all fantastic and they stay on top of what they know, and they share that with you, and they help you become as successful as you can be. You definitely want them in your corner. So thanks again, Jim, for joining us, and I'll look forward to talking to you during the next SVL Insights.
Thank you, Erica. Good to talk with you, and look forward to talking with you again soon.
Okay. Bye, everybody.